Okay, good morning again.
Morning, Judge.
We're here on case 20-1802, Martins versus Magical Cruise Company. Again, these arguments are being live streamed. Each have 20 minutes aside. Mr. Anderson, how much time do you wish to reserve for rebuttal?
5 minutes, Your Honor.
Okay, I'll try to help you in that regard, and you may proceed with your argument.
Good morning again. Ralph Anderson again on the behalf of this time, Ms. Martin, who's the appellate. And once more, I'd like to point out that also in the room with me is trial counsel Julio Ayala. Your Honors, the trial court denied a post-trial motion for attorney's fees on the ground that we did not present evidence during the jury trial as to the amount of fees. Our position on this appeal is that ruling was erroneous and based on an erroneous view of the law. Disney doesn't dispute that we were entitled to an attorney's fees award given the jury's determination that it was acted arbitrarily and willfully in failing to reinstate maintenance and cure. Disney,
let me ask you this: Does our decision in this case could it be impacted by our decision in the prior argument we had this morning?
Well, I believe so. This case, attorney's fees in this appeal, attorney's fees in this case are only available for a willful and arbitrary denial or failure to reinstate maintenance and cure. So I guess conceivably, if the court grants a directed verdict on punitive damages, then that would impact this appeal. But of course, we believe that the court should not, and therefore this appeal is viable and certainly needs to be addressed. Beyond that, Your Honors, I mentioned in the prior appeal the Vaughn rule. Well, the Vaughn rule not only is important for its decision that all ambiguities and doubts must be resolved in favor of the crew member when a ship owner is making maintenance and cure decisions. It's also important because it determined that punitive damages can be awarded in a maintenance and cure case where there is willful or wanton or the type of behavior that the jury found occurred here.
Mr. Anderson, here we have jury instruction 14 that addresses attorney's fees and instructs the jury to consider attorney's fees. How do we get around that? Because I think we need to presume that the jury does what they're instructed and considered attorney's fees. How do we get around that here?
We get around that by looking at jury instruction number 8 and also looking at the verdict form in this case. Jury instruction number 8 is the only instruction that deals with damages in this case. And in that jury instruction, there are 2 general categories, and we can find this in the record in this appeal at page 52.
Well, jury instruction 14 addresses damages too. It talks about additional damages, including punitive damages and attorney's fees.
Well, yes, Your Honor, but in terms of actual laying out elements of damages, it's jury instruction number 8, which is mirrored by the verdict form in this case. So the verdict form in this case, the only damages that the jury is asked to consider are the damages that are set forth in jury instruction number 8. So our position is that when you look at the instructions as a whole with the verdict form, which the parties agreed to submit, that what you have here is an entitlement. We had the entitlement to fees by the jury's determination on punitive damages, but there was no decision or arguable decision on the amount of attorney's fees in this case, because the jury wasn't asked to assess them or at least to quantify them. As a matter of fact, during closing argument in this case, throughout the entire trial, from beginning to end, there is no discussion, no evidence, no nothing about attorney's fees other than in this jury instruction. This was not.
Mr. Anderson, was the, so it was number 14 in that jury instruction, you're submitting that it was an error to include the language about reasonable attorney's fees?
I would think that it's perhaps surplusage. It's a standard jury instruction from the 11th Circuit. It's a pattern instruction, which originally was submitted by Disney in this case, and I will concede that we did not object to it. So that's my explanation of it.
Was it the jury's, are you saying the jury should have determined that it was surplusage, if you would, and not take that into account, or are they supposed to assume that they are supposed to consider that? I mean, what's the jury supposed to do with that?
I think that when you look at the instruction in conjunction with the verdict form and jury instruction number 8, and the way this case was tried, and particularly the closing argument, that there was no instruction expressed or applied to them to actually determine or somehow or another tuck within the verdict form an award of attorney's fees, which is what Disney is trying to argue here, is that somewhere in this verdict form there's an award of attorney's fees. Well, our position is that just doesn't bear scrutiny. So there's no risk of a double recovery here, and there's certainly no risk of the trial judge were to award attorney's fees here. No risk that it's second guessing the jury, because the jury didn't determine amount of attorney's fees in this case.
Mr. Anderson, the case law treats attorney's fees and punitive damages as separate items, don't they?
Yes, they do.
They don't say you can award punitive damages, which includes attorney's fees. They're always separated as two different things, aren't they?
Yes, they are.
And even in the instruction, which talked about attorney's fees, that's still separated out as two separate items, didn't it?
It did.
But the question on the verdict form is only one for punitive damages that doesn't mention attorney's fees, does it?
That's correct. And that's why we think that there is no implicit or certainly not explicit request in either the instructions or the verdict form, or with the gloss upon both of those by the closing argument, there wasn't any request that they actually include an amount for attorney's fees. And it's, doubly true, because in this case, there was no evidence presented as to attorney's fees, because as we pointed out in our brief, we believe that it was understood from everybody involved, at least counsel for the parties, that this was an issue that would be dealt with post-trial, which, as we all know, typically is the case in cases where there is an attorney's fees award.
Is there anything in the record pre-trial confirming that assumption or agreement?
No, there is not. However, there is a couple of other indicia that was the case, and that is there was never a motion for directed verdict in this case as to attorney's fees. If in fact, as my opponent probably will argue, that this issue was to be sure presented to the jury, and we failed in our burden of producing evidence at the trial as to attorney's fees. Well, if that were the case, then you would think that there would be a directed verdict motion. There was no directed verdict motion, and that distinguishes this from their principal authority, which is I believe the Holmes case, which there was a directed verdict motion. There was an objection lodged by the defendant as to the jury instruction, and that makes, certainly in that case, it became an issue. Here it never did. And it was, like I say, it was just not mentioned, and it was included in jury instruction 14 because it is a part of the pattern jury instruction. And I'm not sure what else I can say about it. And that's our position on it. And there is one more thing. Before we filed our motion for attorney's fees, the trial judge held a hearing on post-trial motions. That was January 23rd, 2020. Prior to that hearing, we had filed a motion for final judgment, and part of that proposed order or proposed final judgment was a sentence that says that the judge reserves jurisdiction as to attorney's fees. The only objection that trial counsel for Disney made at that time was that, wait a second, Your Honor, you can't do that because they never pled attorney's fees in their complaint. Well, counsel was factually incorrect. We did plead attorney's fees in our complaint. There was no discussion about what we're talking about today. So that's my, I guess, response to that practical question of whether or not the parties just assumed that this would be held post-trial. But that assumption, we think, is supported by the case law. And we've cited the cases that support our position. The Clausen case, which is from the Supreme Court of the state of Washington. The Incandela case, which is from the Second Circuit Court of Appeal. The Hicks versus Tug Patriot case, which follows that in the Second Circuit Court of Appeals. So we think that the better reasoned decisions are the decisions that recognize that the Vaughn holding that attorney's fees may be recovered in a maintenance and cure case, that holding is based on the court's equitable admiralty jurisdiction. And that's what numerous cases, including the Supreme Court, post-Vaughn, have attributed to Vaughn, saying it is an equitable exception to the general rule disallowing attorney's fees, absent a statute or a contract which provides for them. As the court knows, equitable matters generally are decided by judges and not by courts. And we cite the cases for that proposition in our brief.
You argued, counsel, you argued in your brief that the trial court was wrong in relying on Gloucester Cruise Lines versus D'Souza, but in fact, that was the only controlling authority in Florida at the time, and the trial court had to follow that, didn't it?
Well, you're right, but that doesn't mean that.
You're asking us basically to come to a different conclusion than Gloucester did.
Oh, yes, absolutely. I think that we frankly point out that we believe it is wrongly decided. And well, arguably, Your Honor, there was another decision which we also point out in our brief. We don't emphasize it too much, but the third district before the Gloucester v. D'Souza decision decided another case dealing with attorney's fees in a maintenance and cure case. And
right, but that case didn't discuss whether it's a judge or jury question. So
I agree with you. And
they're out there, but they're not totally in conflict. They might have gotten different results, but it's not like one says it's a judge issue and the other says it's jury. The first one was silent on that, wasn't it?
Yes, Your Honor, it was. We think that fairly read, it supports our position, but I certainly understand Your Honor's position. And that's why that is not our main point. We're not saying, at least today, that Gloucester could not hold the way it did in light of the Canales decision, but we are saying that Gloucester is wrongly decided because it relies on the Holmes case, and both of those cases, in our position, are refuted by better reasoned analysis in the cases that I just discussed, the Clausen case and the Incandela case and the Hicks versus Tug Patriot case, all of which recognize, certainly the Clausen case explicitly recognizes that Vaughn attorney's fees are part of the admiralty jurisdiction's equity jurisdiction, which is something that typically is handled by judges and not juries. And I think it's also important to note that in the Vaughn case, there was no issue as to who, for lack of a better word, should decide the amount of attorney's fees, judge or jury, because that was a bench trial.
Right.
So it was not presented in that case.
In Clausen versus Icicle, they talk about the inefficiency of presenting the attorney's fees during the trial. But I mean, again, Florida often has sequential trials, especially where it's punitive damages. So here, there would be nothing to prevent the court from having, here's your comparative. Phase 2 would be, here's your punitives, and either in the amount of punitives, you could do the attorney's fees, or even as a phase 3, you could do attorney's fees, correct?
Well, I believe, yes, it's theoretically correct. Now, whether it's the best way to do it or a practical way to do it, I think reasonable people can disagree about that. But certainly the trend in Florida, trend nationwide, is to have attorney's fees decided by the tribunal or the finder of fact who is best equipped to decide those matters. And I don't think there's too much argument that that is a judge and not a jury, because if we were to take that approach where you do it in sequential stages, the jury would be held over for another day or two, because under Florida law, to get attorney's fees, and I assume that would apply in this maritime case, you have to have expert testimony, etc. So it is not like you would just be having the attorney get on the stand and say, here is what, how many hours I spent and here's my hourly rate. It's not like that. It would be to a certain extent, another mini trial. And so we believe that that's not practical in terms of from the jury's point of view. So in summary, I'd like to reserve some of my time or keep some of my time for rebuttal. We respectfully request that the court reverse the trial judge. And in the alternative, I forgot to mention this, the Kloster v. D'Souza case did not outright deny attorney's fees. What the court did was it reversed and remanded the matter of attorney's fees to be submitted to a second jury. And it did so because the court found that to do otherwise would be unfair and unjust. And we believe that that same analysis applies here. Thank you very much.
Thank you. All right. Mr. Ryder.
Thank you. And again, may it please the court, Jack Ryder on behalf of Disney Cruise Lines. First of all, Your Honor, Judge Evander, let me go back to the very first question you asked and answer it. And that was, if on the companion appeal, this court would reverse and find that Disney did not engage in the willful and arbitrary and capricious actions, that would essentially moot this appeal, because the concept of both fees and punitives flows from that finding. So I did want to confirm that for Your Honor. With respect to the issue, now turning, of course, the substantive issue here. First of all, the idea of whether or not it is more practical to separate out fees between a jury and a judge, that may be a general proposition of law, but the case law on this issue is very clear. Kloster versus D'Souza, which follows the Vaughn case and follows other federal authority, makes clear that the recovery of attorney's fees in these types of Siemens actions is a, quote, non-severable part of the plaintiff's cause of action, relying on the Vaughn case. And the cost of hiring the attorney is considered an element of damages within the context of maintenance and cure. And in the Holmes case out of the Fifth Circuit, the court explained that an award of damages in the form of attorney's fees for willful and arbitrary failure to pay maintenance and cure is a non-severable part of the plaintiff's cause of action and an integral part of the merits of the case. So the idea that counsel is challenging the existing body of law that makes these claims, these fee claims, a component of damages has been, certainly Florida has, at least the Third District Court of Appeal has explicitly concluded that fees are in fact a non-severable component of damages, which I submit is consistent with governing federal cases. And some of those courts, Your Honor, I'll look just briefly. Counsel refers to the case in the Washington case of Clausen. That case, Your Honor, is distinguishable because there the court incorrectly concluded that the fees were not part of the plaintiff's substantive claim for damages. And I don't believe the Clauston case really examined it from that context as the third district correctly did in Gloucester. And counsel refers to this notion of practicality and the idea that it's more practical to have the judge consider it in a post-judgment arena. Once again, however, case law and rules of law go to that issue because under, for example, Federal Rule of Civil Procedure 54D, which in the federal context talks about claims for fees, there the rule explicitly says that they must be made by motion, quote, unless the substantive law requires those fees to be proved at trial as an element of damages, unquote. And that's exactly what we have here. So
Mr.
I'll
Ryder,
turn now.
The verdict form that we have here, sorry. The verdict form that we have here, where do attorney's fees fit in this verdict form?
I'm sorry, Your Honor, I didn't hear the question.
Oh, can you hear me?
I do, but I got muffled a little bit.
Okay, I apologize. Where on the verdict form that we're dealing with here, where do attorney's fees fit? Do they fit under the punitive damages? Question 8, do they fit under question 5, question 6? Where do they fit?
Well, Your Honor, I submit that they fit under the general compensatory damage award under maintenance and cure. And here's why we know that. We know that for 2 reasons. Number one, and Judge Wozniak, you expressed it correctly. You said, how do we get around, you asked counsel, how do they get around the jury instruction? And that was the key question because the instructions have to be read in paramateria. The instructions were agreed upon and the verdict form was agreed upon. So here we have jury instructions that were explicitly agreed upon by both sides and a verdict form that was agreed upon by both sides. When we look at the jury instructions and we read them in paramateria, I disagree respectfully with Mr. Anderson's argument that these instructions did not explicitly direct the jury to consider fees as an element of damages. Instruction number 14 is clear. It says maintenance and cure. And that's critical because here we're talking about the specific element of claim under which fees are awardable. And jury instruction 14 agreed upon says, when a defendant willfully and arbitrarily fails to pay maintenance and cure, the seaman may recover punitive damages and reasonable attorney's fees and costs. And then it says again, finally, this is the last part of the instruction. This is in the record at 61. Finally, it's important to remember that plaintiff cannot recover attorney's fees for the prosecution of the Jones Act claim. She can recover attorney's fees only for the prosecution of the maintenance and cure claim. Now, once counsel plaintiff agreed to instruct the jury as to the non-severable component of recovery referred to as fees as an element of their maintenance and cure claim, it was incumbent upon plaintiffs to introduce evidence supporting their claim for attorney's fees. They instructed the jury about it. So here they instruct the jury that this is a measure of recovery. They then argue it, they reference it by virtue of agreed upon instructions. And the fact that they didn't explicitly introduce evidence is their way. That can't be held against Disney, number one. And number two, with respect to the verdict form, the fact that the plaintiffs did not explicitly seek a line item for attorney's fees as a separate element of recovery really goes to the issue of the fact that attorney's fees are not a separate element of recovery. And Judge Edwards, I think this goes back to your question that you asked Mr. Anderson about the idea of punitive damages and attorney's fees being separate. Now, I would submit that while one could articulate a rationale as to why you would identify them as separate elements on a line item, that doesn't take away from the fact that fees are a non-severable component of the recovery within the context of maintenance and cure. So I submit, yes.
Mr. Ryder, if you follow your argument that if the jury instruction mentions that it should be determined by the jury, the jury instruction mentioned cost as a recoverable item, but nobody's arguing that costs are ever determined by the jury, are they?
Your Honor, in this context, costs, the instruction says what it says. In other words,
the cases don't talk about the jury should award cost. I mean, you've got to admit there's a split of authority. Some cases say it's a jury issue. Some cases say it's a judge issue, right?
Well, I admit that there's case law that does support Mr. Anderson's argument that there's a split. There's no split in Florida, of course, but putting that aside.
Well, there's one in a row in Florida, basically.
I'm sorry, Your Honor?
There's only one in a row in Florida specifically, so it's hard to have a split with one case.
Well, Your Honor correctly highlighted that the previous case, the before Closter, the prior third district case also talked about this issue. And I still think, Your Honor, that the Closter case out of the third district specifically and correctly identified the federal binding precedent, or federal precedent, not binding, but the federal precedent on this issue. But Your Honor, to your point about the idea that costs are still severable, that doesn't eliminate the fact here, okay, number one, that the instruction was agreed upon and not challenged by plaintiff. It also doesn't change the fact that the plaintiffs never proffered a verdict form that presented a separate line item. This was not raised until after the fact. And so I think if we look at Closter and we look at Holmes and we look at the precedent out of the federal cases and out of the I would submit, very persuasive case out of the third district court of appeal, I would respectfully submit that it was up to the plaintiff, especially after agreeing to instruct the jury that fees are an element of substantive damages under maintenance and cure. It was incumbent upon the plaintiff to also present a verdict form if they wanted to separate it out that explicitly had a line item for fees. But they didn't.
Can't you make the argument, though, that since both parties agreed to the verdict form and it did not include fees, that suggested that they were going to have the judge determine fees post-trial?
I don't think, Your Honor, that the court should presume that in light of the instruction. In other words, I think once that Your Honor, would be a fair evaluation or assessment if the instruction did not explicitly say that fees are an integral component of the plaintiff's recovery. So I think.
Let me ask you this.
Yes, Judge.
As Judge Edwards pointed out, Closter was binding on the trial court. And there are two parts of Closter. One was, that it's a jury issue, but the second was the remand instruction from the third DCA was to hold a new, have a second jury decide the attorney's fees. Was that ever proposed to the judge in this case?
I do not believe it was ever proposed at the trial level. I believe it came up post-trial when we argued the fees issue. In other words, it was proposed post-trial, I believe. I don't recall the idea of handling a second jury came up before the argument, before I challenged the fees request post-trial. I don't recall.
Right. At the time, the trial judge was ruling and said, no, I think this was a jury issue, had to go to the jury. Did plaintiff argue, well, then, Judge, we'd ask for a second jury?
Yes, they did. They did make that argument in post-trial. They did.
So if the trial judge was bound by Closter, what was the reasoning for the trial judge to deny that request, The trial judge here really ruled on the jurisdictional issue, Your Honor. That's how I interpret it. I mean, the judge went through the levels of analysis, and I thought was what was a very well-prepared order by the judge. And the judge really articulated the analysis, starting with the substantive issue that we asserted, that being that it was a non-severable component of recovery, and therefore it had to be decided in the first instance by the jury, and that jurisdiction was lost. So the first argument that we raised to the trial court, and I think, Your Honors, I would acknowledge it's a de novo standard on this point, on the issue of the jurisdiction. The first argument we raised was that the court no longer had jurisdiction because this was not your garden variety post-judgment fees claim, where it's collateral to the merits. Most of the time, and what Mr. Anderson is referring to on the idea of post-judgment fees arises in the context when fees in the ordinary course are collateral to the merit, collateral to the judgment. So it's not uncommon for a judge to reserve jurisdiction and address fees post-judgment, post-trial, because once the judgment's entered, fees are collateral. What makes this a unique issue is that here fees are explicitly not collateral. Here fees are explicitly a non-severable component of damages in the first instance. That's what makes this a unique situation, and that's what made the third district correct in its analysis, I respectfully submit, as it pertains to the Holmes case, because the federal precedent talks about this concept of non-severability. Yes, Judge. If it's non-severable, so are you saying Closter's half right and half wrong?
No, Your Honor, I think there's a big difference here. I think it was all right. I think it was right completely. The difference in that case from this case is that in this case, the court explicitly instructed the jury to consider fees as an element of damages. Nothing in the Closter case suggests that that occurred. So here we have multiple levels of why the court should reject plaintiff's appeal. On the first level, it's the issue of the non-severability. There's where Closter was correct. Now, Closter identified this idea of impaneling a second jury, but what we don't know about Closter that we do know about in this case is that here the jury was expressly instructed, here you are to consider attorney's fees as an element of damages under maintenance and cure. And I go back to the point that, and I believe the trial court correctly agreed with this, that if the plaintiff is going to instruct the jury to consider fees as an element of maintenance and cure, it is incumbent upon the plaintiff to introduce evidence supporting that claim, or they've waived it. Having said that, and I think Judge Wozniak, you hit this nail right on the head, we can't second guess the jury when they were instructed very explicitly in instruction number 14 that fees are an element of those damages if the court finds that there is an entitlement to maintenance and cure. Once the jury made that finding, we have to, I would submit, respect that the jury understands the instructions and follows the instructions. So there we come full circle back to the verdict form. The verdict form didn't include fees as a separate element because one could articulate that the parties acknowledged that it was an element of damages and shouldn't be separated. So regardless of how we look at it, I submit the plaintiff either should have introduced evidence on fees and failed to do so and thus waived it, should have objected to the instruction but didn't do so and thus waived it, should have provided a verdict form that had a separate line item if they thought it was appropriate and didn't do so and therefore waived it. And ultimately, the court, I would submit, correctly concluded that having failed to address any of those things, that the amount as stated should stand. So unless there are, yes, sir.
Yeah, I do have another question. Once the jury has determined that the ship owner's conduct merits punitive damages, is an award of attorney's fees mandatory?
I don't believe so, Your Honor. I mean, in fact, I don't, let me see how the instruction reads, because
If
it's a
they
fair
find
question.
if they find that punitive damages are recoverable, is it discretionary on the part of the trier of fact, the jury, to award fees, or is it automatically recoverable? In other words, once they find punitive damages, is that the same as a decision on entitlement, and then the only decision left is the amount?
I don't believe so, Your Honor. I don't believe it's mandatory. I mean, even the instruction speaks clearly to that. The pattern instruction explicitly talks about that you can award additional damages, and that's if you find. So I don't.
If you find, that's what I'm saying. I didn't see a clear answer anywhere. It says if you find this willful, arbitrary failure to give maintenance and cure, then you can, and only if you find that can you. But I didn't really see where it was discretionary.
Your Honor, and I'll acknowledge, I'm not aware of a case that explicitly says that if the jury finds willful and arbitrary and capricious, that they must award punitive attorney's fees. I don't recall if that is clear, but I will suggest this. And this goes back to what Judge Evander highlighted and Judge Wozniak highlighted, and that is, what was the jury supposed to do with that language? I think that was Judge Evander's quote. You know, when the jury was instructed this issue, what were they supposed to do with that instruction? And as Judge Wozniak highlighted, how do you get around the jury instruction number 14 that explicitly talks about maintenance and cure? And we presume that they followed that instruction. So here, I suggest that regardless of whether the court concluded that fees, assuming that this court didn't reverse on our companion appeal, assuming that this court concluded that fees were a mandatory result, it wouldn't change the outcome here in terms of rejecting the appeal, Judge, because as far as we know, the jury that was correctly instructed by an agreed upon instruction did contemplate that. They may have just come up with a number with respect. They might have gone back in the jury room, deliberated, and said, well, we've got this instruction that says award fees. Let's offer another $100,000 or whatever. But we can't invade, respectfully, the deliberative process of the jury who was instructed to keep that as an element of damages. So no matter how we look at it, Your Honor, even if the court concluded that fees were mandatory, for all we know, the jury incorporated that in their award. And I don't think the court should undermine that in any way. And unless there are any questions, we ask that on this issue, the court affirm. Thank you.
Okay, thank you. Mr. Anderson, rebuttal.
To address that last question first, this comes from the Closter v. D'Souza case, Disney's principal authority, and it says, at page 50, the end of page 50, quote, "At the conclusion of the trial below, the jury determined that Closter willfully and arbitrarily failed to provide maintenance and cure to D'Souza. As a result of that determination, D'Souza was, at the time of the verdict below, entitled to recover punitive damages and attorney's fees in connection with his maintenance and cure claim." So I think that does suggest that upon the jury's determination of willful and arbitrary misconduct, that there is an entitlement to attorney's fees in addition to punitive damages. Now, as to the other points that my opponent brought up, he cites Rule 54B and the last portion of that rule, which states that generally fees should be presented to a trial judge unless it is an element of the underlying claim. Now, their position, of course, is that it's here fees are an inseparable, non-severable element of the maintenance and cure claim, but that was just Rule 54B was cited by the Hicks versus Tug Patriot case in support of its position that attorney's fees are properly awarded by the trial court post-trial and not by the jury. So obviously the Hicks court determined that, as a matter of fact, just like the Clausen court before it, attorney's fees are not a non-severable integral part of the maintenance and cure claim, such that the jury must determine not only entitlement to fees, but also the amount of fees. And I thought that what Judge Edward pointed out, and I'm sorry that I didn't point it out myself before, is that the jury instruction number 14 does say that a party that proves the entitlement to, shows that the defendant acted willfully and wantonly in failing to reinstate maintenance and cure is liable not only for, is not potentially liable not only for attorney's fees and punitive damages, but also costs. You're right, Judge Edward. Costs, there's no argument here that costs are something that the jury should have assessed. There's no argument that we should have presented evidence as to the amount of costs that we incurred to the jury in this case. It's a matter for post-trial proceedings before the trial court. And that's why, and this gets back to Judge Wozniak's question early on, is there any agreement by the parties in this case to handle this issue post-trial? And like I responded, no, there is not an explicit on-the-record agreement, but I guess the whole context of this matter shows that there really was at least a tacit agreement to deal with it post-trial, because this jury instruction says what it says, but then you have jury instruction number 8, which actually deals with damages, and then you have the verdict form, which actually is the blueprint for the jury's verdict, and there's no place or hint that the jury actually assessed and determined the amount of attorney's fees in this case.
Right, Mr.
I'm sorry, thank you.